He's,
Yeah, by the way, yeah, that's my first motion.
Which one's mine? This one. And you're on.
You can do it if not. The man's involved.
Good morning, everybody. I want to call the June 21st, 2023 meeting of the State Election Board to order. We will begin with our invocation, which will be given by Mr. Lindsay.
Please bow your head. Dear God, we ask today for patience and for wisdom and for understanding and compassion. Let us remember the rule of law, but also remember the acts that are called for regarding mercy. In your name I pray, amen.
Amen. Thank you. Now, Andrew McMillan, who is here, would you please come up? As I announced yesterday, on July 1st of this year, which is, since I've lost track of time, just a few days away, pursuant to Senate Bill 222, the State Election Board becomes an independent agency. And one of the things that we've done in anticipation of that, we have authority to hire an executive director, and that's in the process. We have the authority to hire 2 investigators, and that will be in the process. But I've also thought about what sort of support do we need and where can we get it as we begin to consider what our responsibilities are under this, this new status that we have. Well, one of which is, because I don't have authority to hire a lawyer, although it's not like we don't have enough lawyers on the board, but sometimes you just need somebody in an outside capacity to help us understand what our obligations are and what our obligations are not, and what we can do and what we can't do. So for a few semesters, I've been making professionalism presentations at Georgia State, and one of the things that it's kind of awkward standing up here, isn't it? But this is all about you, so bear with it. Okay. We also need a little humor every now and then. But one of the things that I have talked to Professor Lawler about at Georgia State is her desire to introduce lawyers to paths of practice other than just going into a law firm and practicing law, and whether it's a big firm or a small firm. But she's very interested in at least giving exposure to students who are interested, the opportunity to see how public service is different. In my life, public service, I can tell you, is very different than being in private practice. And so I asked her if there might be somebody interested in their school who's a law student to serve as an intern for the State Election Board. And she identified one of her top students who is standing behind me. His name is Andrew McMillan. And so, Andrew, I want to welcome you to the team and thank you very much for your willingness to fit this in with your other activities, and know how important it is from us to you to have your services. So thank you very much. And so I have asked Andrew to lead us in the Pledge of Allegiance. So if you all stand, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I do want to take up just 2 matters which are not on the agenda, but one of which came up yesterday, and the other of which actually came up in the afternoon yesterday with respect to our processing of complaints. The first is, in the morning when we were considering the Fulton County performance report, one of the things that we discussed with Fulton County was, would they be willing to partner with the State Election Board in trying to come up with a template of things which ought to be evaluated periodically in each of the counties as a way of allowing counties collectively, with large counties and small counties, to develop what it is that's most important, what it is that ought to be assessed from an operational performance standard periodically. And while that whole idea has not been fleshed out, I've gotten a couple of emails from people who were in the counties that have emailed me having watched this yesterday and said that they had never thought of an idea like I proposed yesterday, and that the board endorses, and that they are look forward to what we're going to do. What I would like, because Fulton County, including their new chair, Ms. Perkins Hooker, in a conversation when she left yesterday, told me that she was committed to helping and wanted to participate. With that expression, I wanted to ask anybody, especially the county people that are watching this or listening to it, that if there is anybody who would be interested in talking to us about being a member of a working group to work with Fulton County and others that have expressed an interest in being part of that initiative, if they would please email Alex Harden. Alex, who is our paralegal, she will accumulate those names and we'll see who's interested and try to get that group organized quickly. The second issue procedurally is that yesterday we considered a complaint having to do with mismatched documents and ballots and applications concerning Denise Cobb. During the course of that, there was some confusion, including on my part, whether we had passed a resolution in which, or voted on a disposition of that by finding a violation, but instructing a letter of instruction be given. And then as we went through some other ones individually, we realized that we really needed to maybe do them as a group because there were so many so similar. So another motion was presented in which Ms. Cobb, having already voted on something on the complaint against her, was included. So we have Ms. Cobb now is the person who now is dealing with two inconsistent votes of the board, and we need to procedurally correct that. I'll note that Ms. Cobb apparently left because she thought that we had voted on her complaint, so I think she had every right to leave thinking that that was done, and then something happened when she wasn't here. So here are our options for the board, and I'll ask what they would like to do. If we decide that the board wants to, instead of giving her a letter of instruction, referring her case to the Attorney General's office, the matter that was taken up when she was not here, we will have to give her another notice of the complaint, that she is a respondent in the complaint and that she has a right to appear at the next meeting in order to respond to the complaint again, so that we can decide what we should do. If we elect not to do that, we'll need a motion saying that the motion that included her for referral to the Attorney General's office, that she be removed from that motion, in which case the action that we initially taken, which was to find a violation and send a letter of recommendation, a letter of instruction, would stand, and that's the course that we would take. And let me check with our lawyer to make sure I've explained that adequately.
That makes sense.
Okay. So what would the board like to do?
Mr. Chairman, in the interest of fairness, I believe that we need to, I need to make a motion to reconsider the decision regarding Ms. Cobb, to refer that to the Attorney General at this time, and ask for the board's approval, as to that, and then I would make a motion to continue. The problem is that the evidence was her testimony was inconsistent with the documentary evidence that I think warrants further investigation. But in the interest of fairness, to allow her to come and explain herself again before we make a final determination, I think it's important. So for that reason, Mr. Chairman, at this time, I would move to reconsider Ms. Cobb's, the decision to refer Ms. Cobb's case to the Attorney General.
And that we then put that on, give her notice of the reconsideration and the complaint, and that we will hear from her again.
Yeah, I mean, if we can do it in one motion, that's great. I was going to do it in two, but if we can do it in one, all the better. We move on to the next matter.
I think let's do it all in one.
Okay. I moved to reconsider and to continue her case to the next hearing of the State Election Board.
Which would require, if she's on that agenda, to send
Yes.
her new notice.
Correct.
Is there a second?
Second.
It's been moved and seconded that Ms. Cobb's case be reconsidered at the next meeting of the State Election Board, that we give her notice of the reconsideration and that, and give her the opportunity to respond again to the complaint that has been filed against her. Is there any discussion?
And for discussion, do we also need to reconsider the ruling that gave her a letter of instruction? Don't we need to reconsider that too?
Let me put it this way. I move to reconsider any and all
Okay, got it.
determinations yesterday regarding Ms. Cobb and move as part of my motion to continue her case to the next State Election Board meeting with her being provided with sufficient notice to appear.
Is there a second to that? Second. All right, is there any further discussion? All right, all those in favor say aye.
Aye.
All those opposed, no. It passes unanimously. The next order of business is a petition that's been filed with the board that has been put on for the hearing today. There will be two sets of presentations to us. The first will be a 20-minute aggregate presentation by the petitioners. There are two. One is the Coalition for Good Governance, who is represented by Marilyn Marks, and the second is a petition which is substantially similar to the petition filed by the Coalition for Good Governance, and that is, the petitioner in that case is Jean Dufort. At least she will be representing the petitioner in that case. So with that, I will turn the floor over to whomever of Ms. Marks and Ms. Dufort wants to speak first. Welcome.
Is this microphone on?
Yes.
Okay, great. Good morning. Good morning, members of the State Election Board. Thank you so much for letting us speak today. Ms. Dufort and I will divide the 20 minutes between us. I'll be speaking for Coalition for Good Governance. She'll be speaking for the Morgan County Democratic Committee. And we had planned to do this. I'll spend about 7 minutes, she'll spend about 7 minutes, and if we could, we would like to reserve the remainder of the time to come back after your staff has presented to answer anything that we feel like we need to from there. So thank you for considering our rules petition today.
Excuse me, when you first asked for time, I gave you the time of 20 minutes. So we're going to have two 20-minute presentations, and we're not going to reserve any time, so you need to use that judiciously.
Okay, thank you. So it's clear over the last year from the publicly reported events that a vulnerability and incident management reporting system, which is a mandatory system, is urgently needed. When we recognize that the vulnerabilities that were detected and reported by Dr. Haldeman were reported to the state in the summer of 2021, yet no mitigation measures were taken or addressed for 2 years, even to attempt to protect the 2022 midterms. And now those vulnerabilities are public, and the state is saying that yet, still, it will not mitigate those vulnerabilities through the 2024 presidential election cycle. The vulnerabilities remain unaddressed, and the risk of their exploitation greatly elevates because of the Coffee County breaches. If all of us here have learned anything from Coffee County and the breaches that occurred there, it is that there is no effective security incident reporting management system in place or mitigation system in place. The The breaches occurred in January 2021, and the extent of them and the widespread impact is still not fully understood and not investigated. As recently as last night, the Coffee County Board of Elections met and concluded that simply terminating Misty Hampton, the then election supervisor, was sufficient. And although some of them were actually involved in the breach and were aware of the breach, that they concluded that simply terminating the person, actually not even terminating her, but allowing her to resign, separating from employment, was plenty. That's all that was required. They concluded that again last night. Yet, this was the largest voting system breach we ever aware of in the nation's history. So clearly that shows that there is a compelling need for a mandatory reporting system for vulnerabilities and for security incidents, and that reporting needs to come from election officials. Gabe Sterling said in his February 2022 deposition that if in fact imaging of an EMS server had actually occurred, it would require mitigation, yet that mitigation has not been accomplished all this time later. We fast forward to November 2022. The state learned that Ms. Hampton from Coffee County had also been given access and programming rights to the voting system in Trutland County. Yet no action was taken until we at Coalition for Good Governance were able to get a few scraps of documents 5 months later in March. And then, of course, I contacted you, Judge Duffy, to let you know of that situation, and you reacted promptly in getting investigators on the case. But these are situations of security incidents of the type the Secretary of State should have been notified of immediately, or perhaps was notified, but yet there were no requirements for incident reporting or to be able to address those. So what our rules do is make reporting mandatory by election officials and work through mitigation measures that are required when that's been reported. In recent years, the board has promulgated rules, election rules, that govern the deployment of the backup balloting system when the system is inoperable or it is unworkable in some way. What we're doing is asking you to expand those rules to include not just the type of physical inoperability that might occur in a power outage, but in addition to promulgate rules that expand the rules already on the books for security incidents as well. We want to be clear, we are not asking for emergency rulemaking. In fact, we think that very deliberate process needs to take place, your normal rulemaking process that would allow for public input after the proposed rules, they may need to be tweaked, are published. And in fact, I can think of some things now that it's months later since we first proposed these, I can think of some things that need tweaking now with the knowledge that we've gained just since we proposed these. So I want to make sure that we're clear about that. So if the board adopts these rules, we hope that they would be quickly followed by robust and complete policies and procedures that would give the election officials a step-by-step manual on what to do and what to do rapidly when security vulnerabilities and incidents occur, when vulnerabilities are noted and when they occur. We can step through the rules if you want, but in general, I think you're well aware that the proposed rules define vulnerabilities and define incidents, and then require reporting on a certain rapid response timetable by the election officials. Then we step to mitigation. Mitigation is required to take place for security incidents and serious security incidents such as software access. Assumed software access would have an immediate mitigation of going to the rules that are currently in place for the backup balloting system, hand-marked paper ballots, followed by much more robust audits during the time that the security incident is being assessed and mitigated, and that before the state would return to the standard method of voting, that this board would meet in conjunction with the Secretary of State in a public hearing and determine that the mitigations were sufficient for security mitigations. And that's kind of the sum and substance of what we have proposed. And we would greatly appreciate your favorable consideration and certainly the opportunity for the public to make needed refinements for your consideration. We'll look forward to answering any questions that you have.
Thank you. Mr. Ford?
Thank you, Marilyn. Good morning. My name is Jean Dufort, and I'm here today on behalf of the Morgan County Democratic Committee. Last September, when videos from Coffee County were just emerging, I stood before you on behalf of a coalition of Republicans, Democrats, Libertarian candidates, organizations, and citizens, asking you then to take action to protect our elections. My question that day was, if not now, when? What would it take to convince you to protect our elections? Here we are 9 months later, and the Secretary of State has done nothing that would protect our election from future cyber risks. 2.5 years ago, the software that powers Georgia's election system was copied, uploaded to the share file, and downloaded multiple times. It was, as Marilyn said, the largest, and I would add the most well-documented election security breach in U.S. history. 2 years ago, Dr. Alex Halderman filed a report so alarming that it was promptly sealed in federal court, and that report documents specific multiple vulnerabilities that could be exploited to change outcomes. Our nation's agency, tasked with protecting critical infrastructure, and election systems are critical infrastructure. The DHS Department, the Cybersecurity and Infrastructure Security Agency, known as CISA, because that's a mouthful, they confirmed Dr. Halderman's findings, and they recommended prompt mitigations be taken. That was a year ago. The Halderman report is now unsealed, and it's available to the public. Yet last month, state's attorneys told a federal judge that partial mitigations would begin in 2025, after the next presidential election. Voters can't wait. America can't wait. The path to the 2024 presidential election runs through Georgia, and it is unfathomable why anyone would refuse to protect our elections if they had the power to act. We know that some people are willing to do anything in pursuit of their preferred outcome. 2020 told us that. Secretary of State, independent from you, right, as of July 1st, clearly prefers to protect Georgia's voting system from criticism rather than to ensure our outcomes reflect the will of the voter. He's promoting, and his staff are promoting, we'll hear it in a little while, I suspect, the false narrative of the MITRE report, the false premise. They're not mentioning the false premise of the MITRE report, that the vulnerabilities, while real, can't be scaled. That's what's being trumpeted. It was told to a statewide call of election officials yesterday. It's in the press release, it's in the press. But the Secretary of State is choosing to overlook the footnote on page 1 that MITRE's findings assume strict and effective controlled access to Dominion election hardware and software. Let me repeat that. The MITRE conclusion that Alex Halderman's vulnerabilities can't be scaled is dependent on the premise that we have strict controls access to that system. And whoever wrote the unsigned MITRE report must be the only person in America that hasn't watched the Coffee County videos. So members of the State Election Board, it's up to you to act. Fair, legal, and orderly elections. I don't know who wrote that, but that's the watchword on your website. Great basic standard and commitment. Every one of us learned before kindergarten that there's nothing fair about a rigged game, and there's nothing fair about a rigged election. The election system software that powers our elections has been in the hand of partisan actors for 2.5 years. We've seen their texts. They have expressed intent to use it to change election outcomes, and they believe they can do it. That scares the hell out of me. My grandmother would not be happy. Our proposed rules tell local election officials that they must report security incidents and act swiftly to preserve evidence. They also commit all Georgia election officials to act first to secure the system before investigations are completed. Quite simply, you put out the fire before you call in the arson team. I've heard a lot about waiting for the GBI. I read your frustration with the slowness of the GBI. And I'm all for holding people accountable, but that is not the right way you deal with cyber incidents. First you protect the system, and then you do your investigation. You can't wait until after the investigation. It's common sense, and it's the standard operating procedure for companies and institutions across the world when dealing with cybersecurity risk policy. When you use electronic systems to secure your valuables, money, ID, votes, you have to have a robust plan for how to act when breaches occur or vulnerabilities are reported, and it's got to be fast. If your financial institution told you they'd found a software vulnerability that could compromise your account, and by the way, they'd also had a breach, you would close your account if they didn't also tell you what they had done to protect your funds. We all would. Since we filed this petition, I've been talking to voters across the state. Once I finish presenting, the first question is, why didn't we know about this risk to the 2024 election sooner? And then they ask, well, why isn't the state doing something, or what's the state doing? And then they say, how can I help? Some of those people have been writing to you, because that's one of my answers. These are the guys who can do something about it, so tell them how you feel. Don't tell me. Voters across Georgia are shocked that state election officials haven't done more to protect our elections. If you refuse to adopt common sense security incident rules now, it'll be hard to explain why, when our elections depend on an electronic system that has known vulnerabilities and has been compromised. Let's spend a few minutes on why protecting the ballot itself is the simplest way to protect the 2024 election, because the entire system was breached. But think about the voting process. Voters make selections, ballots are scanned, votes are tabulated, audits performed, rules are certified. Really, in the scheme of all business models, voting is not a complicated business. I ran handmade factories in India. There's a little more complication in that, all right? We can overcome a hack of the scanning and tabulating part of the system with robust audits, but a hack of the ballot itself is a fatal attack. Audits are meaningless if you don't have confidence the ballots you're auditing reflect the will of the voter. And the ballot created by a touchscreen and a printer is the most vulnerable part of our system. One of my attorney friends calls the BMD ballot hearsay evidence that wouldn't be admissible in court, because it's how the computer says you voted, not what you actually marked. And computers are vulnerable to hacking, especially in Georgia, in light of the January 21 election system breach and the vulnerabilities documented by Dr. Halderman. In light of the increased risk, just inverting how we use our system. Most people who deploy the Dominion system around the country use it in a different way than we use it. In most jurisdictions, most people mark their ballots by hand, and a few people use those touchscreens and printers. In Georgia, we're all in on touchscreens for everybody who's in person. So just invert it. Use it in what I would call the standard way and everywhere else except Georgia, right? It's a simple and effective way to greatly reduce the threat. Because if you have a ballot that you know is absolutely reliable and not vulnerable to a hack, all the rest of the possible hacks can be overcome through good audits, recounts if necessary, if you have the original will of the voter. We have a backup balloting system. Maryland referred to it to be used when it's impossible or impractical or unusable. It's the legislator started with that system. You and your rules defined it. But up until now, we have mainly imagined that that's a case you use when you have power outages or you have equipment malfunction, like happened countywide in my county in November of 2020, and we switched over in every precinct quickly. 7 a.m. voters walked in, the cards wouldn't code the tablets, boom, hand-marked paper ballots. 4 hours later, the Dominion tech got there and made the system work again. It is not hard, and voters don't care. They just want to come in and vote and know their vote counts as cast. I've talked a little bit about the why you should act favorably on our proposed rules today, but let's review quickly what they do. Adopting the rules proposal gives you, the state election board, some powerful tools you do not currently have. You can hold people accountable if they don't follow these rules. That's most of what you do, right, is hold people accountable. They create a common understanding of what constitutes a serious security incident. They require immediate reporting of any suspected security incident, and this is important. They require local election officials to preserve important evidence, like security footage. We only have the footage of the Coffee County breach because they preserved it for a different reason, a personnel reason, right? But we could have looked at that. Inspector Josh, who encountered Jeffrey Lenberg in January in the coffee office, could have asked to look at the video. And obviously concerns would have been raised much more quickly and come to your attention much more quickly. So that preservation of evidence piece is a super important part. They commit investigators to act swiftly to determine whether the incident presents a likely threat, and if so determined, requires swift action to sideline the equipment that is the most vulnerable, those touch screens and printers, and keep it sidelined till the risk is over. Elections are our public treasure. They're the cornerstone of our democratic republic. So these rules require a public hearing where state officials can present findings and explain to the public why it's safe to resume standard operating procedure. From where I sit, and I'm going to call it we, I'm a communitarian. I mean the Morgan County Democratic Committee and all the people I've been talking to in the last month. From where we sit, the single best way you can act to promote confidence that our election system produces outcomes that reflect our collective votes is to see state leaders commit to having a responsible set of rules in place to deal with security breaches swiftly and commit to enforcing those rules.
Mr.
Putting it
Ford,
more.
excuse me.
Yes, sir. Am I out of time?
You're too much like me. I sort of get wound up and lose track of time sometimes.
Am I out?
Well, you're close.
Okay.
So if you could.
I'm wrapping up.
Great.
I'm very close to the end. Today might just be another meeting day for you, right? Thank you for your service, by the way. But it's a consequential day for the voters of Georgia and the American people. The Secretary of State's office has made it abundantly clear that they will not act, despite the advice of CISA and our top experts in cybersecurity. So you alone, as an independent body, can make the choice to follow the science, follow the experts of how to manage cybersecurity risk, or punt, in which case our 2024 elections will remain at risk. You have the power to act. The question is, do you have the will? I appeal to you for your favorable consideration of our rules. Thank you.
Thank you. Your closing remarks sentence might be where I want to go next, which is, and you can sit down. Go ahead. It's one thing to have power. It's another thing to have will. You can't have will unless you have the authority to do something. There hasn't been any discussion here this morning, nor is there any discussion in your petition about the authority that we have under Georgia law to do the things that you've requested in your petition. So I've asked, because Andrew didn't have enough time to do this legal research project, but I've asked the Secretary of State's office not to address the decisions that they've made with respect to 2024 and the update. What I've asked them to do is simply, based upon their experience, to discuss with us legally what the board can and cannot do, in their opinion. And we have independently, as lawyers, looked at the authorities before we even got the chance to hear what they're going to present to us this morning. But I think it's important for everybody to understand what the law is upon which the coalition and you are requesting that we act. And you're stuck with 4 lawyers that's on the board that say we always have to be cognizant of what we can and can't do. My wife says it is that the law makes you stay in your lane, and we want to stay in our lane, and we can't really consider what's been requested until we understand what our authority is. So with that, I'm going to ask the Secretary of State's office to make their presentation. They too only have 20 minutes. Well, I would say they too have 20 minutes, which is a long time. At the Court of Appeals in the 11th Circuit, you only get 15.
Good morning, Mr. Chairman and members of the board. Thank you for the opportunity to present to you this morning. And at the board's request, I am presenting the Secretary of State's position on the petition and will specifically address the chairman's question about what Georgia law requires and what the authority of the State Election Board is. We did provide the board with our detailed written comments last week as the board requested. So I will use my time this morning to highlight some critical information that the board should consider when taking up the petition. But the chairman really hit the nail on the head right now with the threshold issue, and that is, what does Georgia law require? And first and foremost, the board should deny the petition because the proposed rules are contrary to Georgia law. The petitioners are asking the board to make sweeping changes to the state's method of voting via rulemaking. But the method of voting in the state of Georgia is a policy decision that should be made by the Georgia General Assembly. And any changes to the state system of voting is a decision that the Georgia legislature should make. But let me be clear. The state's electronic voting system is safe and secure as verified by independent testing and has been proven over the past 4 years to produce accurate election results that Georgians can have confidence in. Our system is battle tested, and the Secretary of State welcomes any opportunity to describe in detail how the state is a national leader in providing secure, fair, and accurate elections. The recent politicized attacks criticizing the security of our system are being made by those who want to sow distrust in the integrity of our elections and cast doubt on the accuracy of the results. But the Secretary of State will continue to provide secure elections, protect the security of our voting system, and any changes to the system will be done in a deliberate, informed, and responsible way. We will not be reckless with the security and integrity of our election system, especially going into a presidential year. And we will not take the drastic action of making major changes to our system and our voting software without testing it first. And any responsible actor should agree with this. But turning back to the threshold issue, the board should deny the petition because it is contrary to Georgia law. The election code mandates a uniform system of electronic voting utilizing ballot marking devices that produce verifiable and auditable paper ballots that are tabulated by optical scanners. This is an OCGA 21-300. The General Assembly enacted this law and made the policy decision to adopt this system of electronic voting in 2019 when it enacted House Bill 316. This law requires all counties in Georgia to utilize the same uniform method of electronic voting for all federal, state, and local primaries and elections. The state of Georgia made a substantial investment in purchasing new equipment for all of our counties. And this equipment has now been safely used for the past 4 years and in 2 statewide elections. The petitioners asked the board to promulgate rules that would ignore the clear statutory mandate that counties use a uniform system and give county election superintendents the discretion to use hand-marked paper ballots if the superintendent determines that a security incident has occurred. However, there is no provision in the Georgia Election Code that supports the creation of such a broad exemption to the clear statutory mandate that all counties use a uniform system of electronic voting. And any decision to create such an exemption is a policy decision that should be made by the Georgia General Assembly. And although state election board rules do allow election superintendents to use hand-marked paper ballots in an emergency, that is a narrowly defined situation where voting on the equipment is impossible or impracticable. In other words, when the voting equipment simply doesn't work and can't be used when voters need to be voting. The overall purpose of the state election board rules is codified in the election code as to obtain uniformity in the practices and proceedings of county election officials. The petitioner's proposed rules are vague, overly broad, and likely to be interpreted and applied inconsistently between counties. This will undermine the very uniformity in election administration that the board's rules are intended to achieve. It will also require retraining of all county election officials on new procedures. And it will be confusing to voters who expect to show up in person and vote on the BMDs that they are used to. And most importantly, the relief sought by the petitioners is contrary to the expressed will of the Georgia General Assembly that all counties use the state's uniform system of electronic voting. And for this reason alone, the petition should be denied. But the petition should also be denied because the petitioner's security concerns are unfounded. Our voting system has been certified as safe and secure by the U.S. Election Assistance Commission and the Secretary of State. It has been through rigorous independent testing and has consistently been proven that the results the system produces are reliable and accurate. Furthermore, mandatory audits have been conducted since the statewide implementation in 2020, which affirm the integrity of our election results. These audits have provided us with confidence that our system is working as intended. And in addition to the certification process and lab testing that has confirmed the security of the system, our election processes have built-in layers of safety nets that also ensure that the results are accurate. First, there are already board rules that require strict physical security measures to protect the security of our voting equipment. Second, before any election, the equipment is subject to rigorous logic and accuracy testing to make sure that the tabulation scanners are accurately reading the printed paper ballots. The paper ballots printed by the BMDs also provide the voter the ability to verify that the choices marked on the paper ballot are accurate. And fourth, risk-limiting audits confirm that the tabulated results are accurate prior to certification. And audits are now mandatory for every primary and election with state and federal races with recent legislative changes to OCGA 21-498. I do want to address one part of the petition related to audits. The petitioners asked that the board promulgate a rule requiring audits for at least 50% of all races on the ballot. We'll say that this is contrary to the audit requirements in the election code, but more importantly, it's simply unworkable, and it's not something that counties can practically do. It would impose significant burdens on them to be able to conduct that many audits within the certification deadline. I would also like to address the petitioner's claim that there are certain vulnerabilities in the system, which they identified in an expert report that was submitted in the Curling litigation. This particular individual is the plaintiff's paid expert witness. He was given unrestricted access to the voting equipment in a laboratory setting for 12 weeks with password information and documentation on how to operate the equipment. And even with all of this access, he's only been able to identify hypothetical vulnerability scenarios rather than concrete evidence of any sort of actual attack. As I noted, this report was submitted in the Curling litigation, and it is just one piece of evidence that is before the federal district court in that case. Both the Secretary and the State Election Board are named defendants in that case, as you're aware, and have submitted their own independent reports that thoroughly rebut the concerns raised by the petitioner. For example, the MITRE report that was also recently released concludes that the proposed attacks in the plaintiff's report are operationally infeasible, meaning that they are nearly impossible for a bad actor to accomplish in a real-world setting due to the stringent safeguards that are actually in place at our polling locations. This includes constant observation by polling officials, and the alleged vulnerabilities were also deemed to be non-scalable in the MITRE report. And to put that in simple terms, it means that the impact of any potential attack is limited to a single device at a time. It cannot be spread to other pieces of equipment without gaining physical access. The petitioners have also pointed to the Coffee County breach as evidence of a further security risk. Let me be clear, the Secretary has strongly condemned the actions of these rogue election officials and those who aided them. We expect that those who violated the law will face the appropriate legal consequences. However, it is essential to highlight that this incident did not compromise the security of any election. We took swift action by replacing all of the equipment in Coffee County, including the server. And even the petitioner's own expert, who has had a forensic image of the Coffee County equipment, did not find any evidence of a malware installation. I also think it's important to note that the Federal District Court has had all of this evidence, a full evidentiary record that has been developed over years of litigation, and the court has taken no action to enjoin or restrict the use of Georgia's voting equipment. So I would submit that the petitioners are coming in before the board to try to achieve before the state board what they have not been able to achieve in federal litigation. As I mentioned before, our election processes have a number of safety nets built in that mitigate the risk of a security threat. So it is extremely unlikely that a bad actor would be able to exploit our voting system in the real world. We would support some sort of reporting requirement as an additional safety net. If this is something that the board is considering, we would submit that any rulemaking on this issue should be done in consultation with county election officials. But looking ahead to the 2024 presidential election that is before us, I want to point out that the Secretary of State's office is taking additional steps to add even more safety nets and enhance the security of our voting system even more. First of all, we are doing system security health checks in all 159 counties to verify the integrity of our election management systems, ballot marking devices, and scanners. Our system technicians will ensure that the equipment is working as it should and has not been tampered with. We are also collaborating with the Department of Homeland Security to perform physical site security assessments of our election equipment storage and warehousing in every county. We also have worked with the legislature this past session and to get expanded pre-certification audit requirements for primaries and elections. And has been mentioned, we are also conducting a pilot of the latest version of the Dominion Democracy Suite software, which is version 5.17. This pilot will be conducted in select municipal elections, and this will allow us to select or to test the new software in a real election setting to determine if it is safe and practicable for use here in the state of Georgia. And our election experts are going to provide a briefing to the board later this morning on this new software. But let me quickly correct some misinformation that has been spreading about the software. First, the 5.17 software version is not a patch. It is a reinstallation of a new version of the software. It cannot be implemented statewide with the simple push of a button. It must be physically installed on every single piece of equipment in every county in Georgia. It will require hundreds and hundreds of man-hours to accomplish this. It also has not been used in an election in any jurisdiction in the United States. We are still in the evaluation and testing phase of the new software version. We will be testing it, as I mentioned, in the fall in a pilot program that will allow us to evaluate it in a real-world setting so that we can certify it as safe and practicable for use as is required by Georgia law before we can use any new component of the system. And one thing that we have learned throughout this testing process and evaluation process is that the new software version is incompatible with some of our voting system components, namely our poll pads that program the voter cards that allow voters to actually use to vote on the BMDs. So had we done what the petitioners asked us to do and rushed forward with an installation of the new software, we wouldn't have functioning election equipments for our fall elections, let alone for the upcoming presidential election. And we've talked about voter confidence. It's difficult to imagine a situation that would harm voter confidence more than if we make drastic changes that will render our equipment non-functional. So this notion that there is a simple and easy fix that will address every security risk that the Secretary is just refusing to do is simply false. And again, those who are pushing this want to sow distrust in our system. They're asking the state to make rash, knee-jerk decisions, which we will not do, because Georgians expect better. And the Secretary of State will not be reckless with the security and integrity of our state's voting system. We will act in a responsible, informed, and deliberative manner that ensures the security of our system in a way that is consistent with Georgia law. We know that the State Election Board shares this commitment to Georgia law and ask that you deny the petition and defer to the will of the Georgia legislature and then let them make policy decisions regarding our election system.
Thank you.
Thank you.
I want to take a moment to reset what we're doing here this morning with respect to these petitions. One thing that we have all learned from this experience, and we saw it play out here today, is that what we requested, what we wanted was a discussion about the actual amendments that were being proposed, not an advocacy about shortcomings in the system, and then we wanted to know what the law allows us to do and not do. One of the duties that we have, which I hope everybody understands, is that we have to detach rhetoric from reasoning. Our responsibility is to reason through a petition without making disparaging or critical remarks of the other side. We take this in a much more pure approach, which is a petition has been filed. There's specific language within the petition. We have to decide whether or not we have the authority to do so. And if we do, what does that look like and what does the process look like? A lot of what I've heard this morning, I have read in emails to me, I've read on presentations by various people in the news, and this is just not the place for that. What I want to do is I want to consider the specific requests that have been made and our legal authority to do that, which ultimately there is some of that information in the presentations that were made to us. So I want to reset that our job is to listen to these presentations and from it take the information that's necessary for us to make a reasoned and informed decision on the petitions. That we don't take sides with respect to whatever philosophical or advocacy position either anybody wants in this. Our job is our mantra, which is we deal with facts and then we apply the law to the facts, and that's what I want to do now. So I hope that resets what our duties are. I've asked Mr. Lindsay, my board colleague, to sort of guide us through this process with respect to the petitions with the help of Ms. Gazelle. And so at this point, because I want to reserve whatever I have to say about this until after I hear the other board members' comments, I want to turn it over to Mr. Lindsay.
Thank you, Mr. Chairman. And if I think I need to turn my microphone on. And if I may sort of start off with, and I think it is important for folks to know where folks start from. And, you know, as someone who's been part of the election system in Georgia for about a quarter of a century, as someone who was a member of a county election board, then I had my name on a ballot for several election cycles. I've been an attorney dealing with election disputes, and now I serve on the state election board. I firmly believe, contrary to some other folks, that an electronic system is a system that, if properly run, is both more secure and more accurate. First off, regarding accurate, anyone who thinks that paper ballots cannot be manipulated, I suggest you read Charles Bullock's excellent book on the 1948 election in Georgia for governor, in which we ended up with a dispute over 3 people claiming to be governor. And when it comes to the accuracy, of any kind of ballot method that involves the human application of their preference versus simply touching a screen, I suggest you go and look at the 2000 presidential election in Florida, which is why so many states, including Georgia, moved to an electronic system. But in order to have an electronic system, you have to have a rigorous process in terms of security and always maintaining that. There are two issues involved in the proposed petition for rule changes. One involves reporting requirements of breaches, of any kinds of breaches. The second is involved what power the state election board would have when it comes to remedial action should a breach take place that folks believe to be catastrophic and requiring alternative methods. And I believe that the intent of the petitioners regarding reporting requirements has merit. I strongly believe it has merit. However, the specific language that is being proposed in here has some fundamental problems in terms of ambiguity and in terms of practicality, and also in terms of protecting that information that may be transferred to this either election board or the Secretary of State should a breach or a criminal activity take place, that I think requires some further study before we move forward with a rule change. And so while, Mr. Chairman, I will be asking for a motion to deny this petition, I'm going to also be making a request that this committee create a five-person study committee to come back with another proposed rule, and that include 2 members of the state election board and 3 folks from various counties, from a large county, a mid-sized county, and a smaller county. And where's my friend from Bartow County? By the way, I'm going to be looking for you on the second category. And someone perhaps from one of the 4 larger counties, also included in the smaller one. Because I do think that we need to try to figure out how exactly a rule would apply, so that should a situation such as Coffee County or any other kind of breach, that we have a requirement for a rapid reporting of that and an ability to do a rapid investigation. I do, however, and I think that one of the presenters even acknowledged that there are possible changes that they would make, and we would welcome their input as well. So I do have, for that reason, I think that at this time, and regarding the specifics of what they propose, we should turn that down, but we should also not ignore the issue involved, and that we should move forward with trying to develop a rule that satisfies at least a great amount of their concerns, including some of their additional input. The second part is what kind of remedial action that we should have and what authority we should have. I think clearly we do not have the authority that they are seeking within these rules, based on my analysis as an attorney and based on the analysis of other attorneys that have looked at it as well. That doesn't mean that some other activity should take place or some authority should take place. Some of that is going to require legislative changes in the next legislative session. And part of our duties, I will tell you right now, is to make recommendations. If you look at our ascribed duties underneath the law, is to make recommendations to the General Assembly. There's an open question as to how much authority should be given to us exclusively and how much of it should be shared with elected officials. I can tell you right now, I am hesitant to give so much authority exclusively to the state election board to change how we vote. I think that probably in an emergency situation or in a situation of a serious breach that in an upcoming election, that responsibility should be shared. But I'm more than willing to work, and I think the board should work with the General Assembly to figure out, for instance, this is simply hypothetical, whether or not an elected official such as the governor were to underneath his powers, give us the authority to then take a look at. In other words, there's a certain check and balance taking place. How exactly that takes place is something for us to work on between now and January. But I do think that there needs to be an ability of the state should a catastrophic breach take place, that we have that ability, but this state election board simply at this time does not have it. And for that reason, Mr. Chairman, I'm going to move at the appropriate time that we deny this petition, but a follow-up request is that we put together a committee that will first look at in terms of reporting requirements, that is both secure, but also puts duties on the counties, and is something that is workable by them, because there is that concern. I do worry about us making rules. For that matter, I worry about the General Assembly making laws that are simply impractical when it comes to our county people being able to act that out. We've seen some of those problems already. And so anyway, Mr. Chairman, that's my report to the committee.
Ms. Gazelle, would you like to speak?
Just very briefly. As a matter of policy, I come at this from a different perspective. Anybody who has followed my activity knows that I actually am a very strong supporter of paper ballots, but as a matter of law, we do not have the authority to make changes to the policies that have been set by the General Assembly. The way that the General Assembly has defined the emergency circumstances by which paper ballots can be utilized is very circumscribed. I adhere to the analysis provided by the Secretary of State. The only time that we can shift from that method is when it is physically impossible or impracticable, meaning it cannot be done. We don't have the authority to usurp what the General Assembly has decided will be the way forward. So I agree entirely with the legal analysis of my colleague, Mr. Lindsay.
Mr. Bashford?
Thank you, Mr. Chair. One of the things that lawyers are very familiar with that the general public is not familiar with is the idea of subject matter jurisdiction. And a court will, the first decision that any court has to make in any case is, do I have the authority over this subject matter? And so it's a jurisdictional issue, and if the court decides that it doesn't have subject matter jurisdiction, it does not proceed any further, and it doesn't even hear the merits of the case. I think the chairman here was wise to allow the parties to address the merits of the case, and so I thought that was helpful. But with regard to the subject matter jurisdiction, another thing that makes me particularly sensitive to it is that each member of the board is appointed by a different entity. There's a Democratic member of the board, or Democratic appointed member of the board. There's a Republican Party member of the board, appointed member of the board. The House gets to appoint one member of the board, and I'm appointed by the Senate. And so while each of us, and the chairman is appointed by both houses, the House and the Senate. And so while each of us represents and works very hard to represent and hear the voices of all Georgians, we do have a particular channel that's set up by statute for us to make sure that we hear. Now, I'm the only member of the board who was here during COVID. And so I remember distinctly passing the regulations that we had to pass with regard to COVID. And that was an unprecedented situation that we were in. It was an emergency. We had probate judges who were election superintendents die. The courthouses were the original super spreaders. So, that was a big issue, and the board acted. But the General Assembly spoke after the board acted in SB 202, and the General Assembly was very clear. If they weren't clear in the statute, they were clear in their communication to me that if we haven't given you specific authority to do something, and it's not an emergency, you're not authorized to act. Now, one of the things that we have to be very careful about on this board, and we are very careful about, is the idea of the unfunded mandate. Now, everybody who's listening from a county and everybody who's here from a county knows that they hate unfunded mandates, and they hate it even when the General Assembly does it. So imagine an appointed board of 5 volunteers, no matter they're the hardest working volunteers I've ever seen on any committee that I've worked on. But no matter how hard we work, we don't have the authority to pass an unfunded mandate and cause the counties to expend money that they don't have and that we don't have any authority to give them. So we got to be very sensitive to that. So I would be very worried in that. With regard to emergency, I heard the petitioners today specifically say this was not under the emergency rulemaking powers of the board. And so therefore, now it's a question of is this our job or the General Assembly's job? And so one of the speakers said that you have a choice of you can either act or punt. And if you're in a debating society or deductive logic class, you'll recognize that as what's called a false dilemma, and that it presents only 2 choices when there might be more. And just one I would present is follow the Constitution might be another option. And so I think the framework of the government that's set up in Georgia is this is an issue, regardless of how good an idea it might be, this is a question for the General Assembly to answer and not for the board. So I will vote to oppose the petition for that reason.
Dr. Johnson?
Thank you. In listening to to the petitioners today and to the Secretary of State, I have several questions to Ms. Dufort, as she stated, protecting the ballot itself is everything. Is every ballot that my question is every ballot that leaves in an election office by absentee secure and protected? Aren't all hand-marked absentee ballots hackable? To Ms. Marks, I am concerned also about the amended petition, that it would potentially create an interrupted election, which would cause chaos and bedlam in the middle of one of our elections. For Ms. McGowan, Secretary of State, the claim that the state uses a uniform method of voting when 1/3 of voters actually use hand-marked paper ballots by absentee voting, and now there's an increasing number of voters that are allowed to use email voting. I question whether we are actually using a uniform method of voting. So, in the last presidential election, 1/3 or greater than 1.5 million absentee ballots were used, and 2/3 were voted by the electronic method of voting. So I think there's things to consider, and I agree with the comments of my colleagues about the subject matter jurisdiction and the remedies proposed. Thank you.
Thank you, Dr. Johnson. You know, it's interesting hearing the comments of my colleagues, which I haven't heard before. This is the first time that any of us have expressed our view of this particular statute. You're hearing it as I'm hearing it, and it's interesting that I take, having thought about this before coming here, that I take a similar approach but with a different perspective, and it's that perspective that makes me support that we deny these petitions. But I want to explain why I do what my analysis is as a lawyer, but also as somebody who, although only doing this for a year, have spent a fair amount of time talking to election officials in the counties, and for the first time really understanding what their job is, how hard they work, and the challenges that they are presented with. in the way that they view us, the board, and the way that they view the Secretary of State's office. As a federal judge, which I did for almost 15 years, I got a lot of federal subject matter jurisdiction, by the way, is a maybe we could turn that off. The notion is that we cannot do something which is contrary to a statute, nor can we do things that might not be directly contrary, but to pass rules that are clearly within the province of the General Assembly to pass. And I believe that that wholly applies here, that the requests made in the petition, and I've focused on the petition, I'll tell you why in a second. One, requests us to do things that have already been addressed by the General Assembly, and for us to act in a way that where we are not authorized to act would be wrong, and as a lawyer, I wouldn't do that. I would hate to have been in Mr. Mashburn's position when he was on the board to get a call from the General Assembly and told that we have our job and you have your job and your job is not to be our job. I think as a basic principle, that's true, that we are guided by statutes that give us the space to act and denies us space not to act. In the years that I was on the court, I spent a lot of time evaluating statutes. And in a way, this rule is the same process, which is you look at the rule, especially when you're considering something that is being proposed, and in the case of a federal lawsuit is challenged. My practice always was to go without listening, without reading any brief, without talking to it about it with any of my clerks. I would look at the statute. And in looking at the statute, one of my questions would be, would I be able to understand it? And I do not understand this, especially the definitions in this statute. I find them to be extremely vague and ambiguous, and would be very, very hard to apply. That would be for me as a lawyer. To say that we would require county officials to interpret what these terms mean to determine whether or not they have some remedial responsibility, I think would be asking them to do something which is they're incapable of doing. And for that reason alone, it's hard to look at the rest of it, because if you don't know what a security incident is, you don't know what a security vulnerability is, how can you then determine whether or not you have, under other proposed amendments, that you've got some duty to act? I do agree that the General Assembly, and we've looked at this language in the past, has really prescribed the incidents in which paper ballots can be used, and that's entrusted to the supervisors within the counties in the event that it's either impossible or impractical to conduct an election using another system. And so, therefore, I think that provision in and of itself runs afoul of the statutes passed by the General Assembly, and therefore it would be, I think, unfair and really imprudent for us to pass these amendments and impose these ambiguities and duties on people in the field. Now, I'll say that after I looked at a statute, my next question always was, why is there a dispute, or why do some people interpret a provision differently than somebody else? And that's important to me, because I want to understand what they're trying to accomplish, and what does the statute try to accomplish, and what does that impose upon the people who are required to follow the statute, and can they do that, is the statute clear enough? This is a really worthwhile request for us to deal with how do we learn of, and then what do we do with potential insecure and vulnerable abilities that arise in the election system. I think that in my lifetime here in Georgia, we've had all sorts of voting systems. I think at one point I took a little thing and punched a computer card in Florida that resulted in hanging chads. And then we moved to a paper ballot, and then we moved to another electronic process, and then we moved to yet another electronic process. All of that, I think, is worthwhile, that we look at changes in technology and whether or not there are systems that are safer, better understood, especially by a younger population, than filling out paper ballots, which I don't know if they fill out anything in paper anymore. But that's just a change in culture, and I think that we always ought to see whether or not changes in cultures ought to be addressed in the systems that government presents to citizens. So the idea that we take seriously vulnerabilities and security incidents, while I don't agree with these definitions, I do think that we ought to consider that. And I agree with, I think, what everybody has said on the panel, which is it's time to do that, so long as we can do that within the authorities granted to us. Some of these, I would agree with my colleagues, are matters for the General Assembly. And in my little taste of interacting with the General Assembly, I've reached this conclusion, that if you go to the General Assembly with a thoughtful presentation of what you would like for them to do, with adequate reasonings why that should be done, with something that is in writing that they can look at to decide whether or not it can inform people who are required to follow that law, that they are a lot more receptive than somebody going down to the General Assembly and talking to somebody in the corridor, which they do a lot of, and say, you know, we would like this, and then turn it over to somebody else to find the solution. My experience is that there's not enough of the pre-work that's required for the legislatures while they're here for their 3 months to be really deliberate and really understand, including the economic imposition that would be imposed upon county election officials and the counties themselves. That all needs to be addressed. And if you do that thoughtfully in something that they can study, and do that other than on the first day of the General Assembly, I think that there is a strong possibility that it would at least be favorably received, might not be enacted, might be changed some, but I think that it would be given more serious consideration. And I see that as what Mr. Lindsay is proposing, is that we do this the way that it ought to be done, which is to have a group of knowledgeable people review these questions that are presented and these remedies that are suggested in the petitions, and that we try to do something that we believe we have the authority to do and which would work, and if we can't do it, to propose to the General Assembly the specific legislation where they could act where we can't. To me, that's a really reasoned approach to the way that we as a board want to do our business. There are security issues. You know, in the short time that I've been on the board, we've had a number of instances where it has to be known, because we know that it happens, that people are storing equipment in unsecured locations. And they have lots of reasons why they do that. And they have lots of reasons why they might give a key to somebody else, because they're really using the facility because it's been given to them by somebody and they don't have enough space themselves. But to give access, to give a key to somebody who is not an election official to be able to enter into that space where machines are being stored, even if they're not, they don't ever intend and they're fully trusted not to do any mischief, is just wrong. It's the responsibility of the election officials to secure the equipment and to make sure that only authorized people have access. And if it means that we have to have security people, then you have to hire security people to make sure that nobody gets access, unless they're authorized. That imposes a financial burden on the counties, and we ought to, including looking at the physical security in addition to whatever electronic vulnerabilities there might be, then we need to address those things, because we know, the five of us know that that happens. And we've heard complaints and have had to respond to complaints of people that don't secure their facilities. So security is a vital issue. The one thing that has always disturbed me is that as much burden as we put on county officials, we impose a greater responsibility on them. And to have looked at all of those videos where somebody who was an elected official holds a door open to allow people that they know are not entitled to see, to touch, to download information from machines is terribly, terribly wrong. And that's why I'm frustrated that it's taking a terribly too long period of time to respond to that. But if you think about it hard, it's that vulnerability that I think has created this furor, at least what Ms. DeFort and Ms. Marks claim is that look at the vulnerability. Well, the vulnerability, that person could just as easily have given somebody access to paper ballots. People that want to act the way that people acted in Coffee County has been acting since the beginning of man. But it's a very physical vulnerability, and we have to find some way of making sure that only people that can be trusted in the election process are allowed to participate in it and certainly manage it, which is why I was equally upset when I heard that at the county whose name I have a hard time pronouncing, Trutland, that person was able to have access to machines in a differing county, and that there was no system by which people that are hiring election officials and election people to work on machines don't get some sort of notification that this person can't be trusted with the machines. That's a security vulnerability in and of itself. And there is nobody has ever developed a system that where we find somebody who's not trustworthy, that we let other counties know that those people should not be entrusted with responsibilities. With the thing that I agree with everybody is that the right to vote is in fact the fundamental way in which you and I have a right to choose who leads us. And we have to do everything in our power to make sure that that right is protected in every manner and way that we can. So unless anybody else has any comments, Dr. Johnson, do you? I'll entertain a motion.
Mr. Chairman, I move that we deny the petition.
Is there a second?
Second.
Mr. Chairman, I move that we deny the petition.
And it's been moved and seconded that the petitions be denied. Is there any further discussion? There being no further discussion, all those in favor of the motion to deny the petition say aye. Aye. Opposed, no. The vote's unanimous and the petitions are denied.
Mr. Chairman, I don't know if you would prefer to hear a motion regarding the creation of a committee at this time, or wish to do so underneath your inherent power, but I'd be happy to give a motion. Propose that a committee of 5 consisting of 2 members of the election board, 1 Republican and 1 Democrat. Guess who's going to be the Democrat? And 3 folks from various counties, 1 from a larger county, 1 from a mid-sized county, 1 from a smaller county, be assembled to first propose rules regarding reporting breaches, and then also make proposals to the board by December well, the first one would be by the next, in terms of the rule part, be before the next committee meeting or board meeting. And then regarding the legislation, be a proposal to the board by December so that we can make a proposal to the General Assembly on any type of legislative changes. And that same group be done for both.
So the motion would be to appoint a committee composed of 2 members of the board, 1 Republican and 1 Democrat, and a representative from a large county, a medium-sized county, and a small county, as determined by
By the chair.
by
You.
me,
Yeah.
by the chair, and that they promptly convene and meet, and by, I would say rather than the next meeting, because we could have a special meeting to do that if we wanted to, in a meeting within the next 70 days, that they report on, how did you put?
Proposed rules regarding reporting of instances of breaches of the state election system.
So proposed rules to report suspected breaches, and then by December 1st, that same group report and make recommendations regarding legislation that we would request the General Assembly to consider enacting during the next legislative session. Is that accurate?
Yes, Mr. Chairman.
Does everybody understand the motion? Is there a second?
Second.
It's been moved and seconded that we move to convene the described group with the deadlines that have been stated. Is there any discussion on the motion? There being none, all those in favor of the motion say aye.
Aye.
All those opposed, no. The motion passes unanimously. Well, I want to thank Ms. Marks, Mr. Fort, and the Attorney General's office, and Ms. McGowan for the information that you provided to us. It was very helpful. And we have acted upon it, but appreciate your input. It's valuable to us, as all input from citizens is valuable to us. So with that, we will move on to our next order of business. I announced yesterday at the meeting that sounds like an alarm telling me that my time was up, and so I take it that that wasn't the case. That one of the things that I did not understand, and one of the things I think a lot of the public does not understand, and it's been alluded to in the presentations made this morning, especially by the Attorney General's office, as to the update that the Secretary of State has announced, and the update would apply to the current Dominion Suite voting system, would be beta tested now, but would not be implemented until 2025. I'm not here to discuss that policy decision, but what I found is I don't know what the update is. I don't know what it does. I don't know what it seeks to address or fix, or how does it seek to expand the functionality of the system. And I think not only should I know that, and everybody else on the board know that, I think everybody needs to know that, because I get lots of emails about the update, and I'm not sure anybody really knows what the update does. It's been characterized, but I think if we are going to evaluate public arguments and arguments here about the update, we need to know what the update does. So I've asked the Attorney General's office, and specifically Blake Evans and whoever else he wants to help explain this. I'm sorry, Secretary of State's office. I assume that the Attorney General's office would not like to do that. Correct? Okay. So if, may I turn the floor over to you to explain to us what the update is and what it does? And it's, I don't want to, I see you're bringing up your rules book. Yeah, this is a fact presentation about what the update does and not a legal analysis of what, how it fits into the statutory scheme, unless it's not necessary to explain.
I agree, don't worry. You've heard enough from me. I'm not going to talk. I'm going to turn over to our elections director, but I just wanted to give my little lawyer disclaimer first that that Georgia law prohibits us from disclosing information that would jeopardize the security of our election system, including software. So there's just certain information, technical information that our staff cannot get into, and I want the board to understand that to the extent they can't answer a question, it's not because they're being evasive, but just we have to protect what information we can disclose.
No, we fully understand that. Welcome, Mr. Evans.
Thank you, and good morning, board. You know, one of the things that we often have to tell counties sometimes is, when we get questions, is you need to, you know, this is what the code says, consult with your county attorney. So I often remind them that I practice what I preach and keep my attorney very close by. But what I want to do today, really, in this presentation, you're going to hear a little bit of me, and then you're going to hear a little bit of Michael Barnes, who is our Deputy Director of Voting Systems here in Georgia. And I'll say that I am very fortunate to work beside somebody like Michael. Michael has been a servant to the voters of Georgia for over 25 years. And not many states, in fact, I don't know of another state that has somebody in the voting systems realm like what we have in Michael. And so he's very, very knowledgeable, and so I'm excited to have him beside me for this. But what I want to do in this presentation is, first, I want to kind of start high level, and then we'll get a little bit more granular, but I want to start with just kind of an overview and defining what the Secretary of State's role is whenever we get a new software installation, like what we have with Dominion 517. And then second, I'll provide some specific context as far as where we're at in the process of assessing 517. And then third, I'll hand it over to Michael, since he is on the team that is actually reviewing 517 for potential state certification. And so first, focusing on the Secretary of State's role. So by the time that we get a new software installation in our office, it has gone through already review and certification by the United States Election Assistance Commission. And what generally happens is that a vendor, in this case Dominion, will submit for review software. And then the United States Election Assistance Commission will get one of the voting system test laboratories, which there are 2 of in the country. Those are commonly referred to as VISTLs. So they'll get one of the VISTLs to review the software. And what the VISTL will do is they'll take the software and they'll run it against what is also called as Voluntary Voting System Guidelines. You might see the acronym VVSG for those. As of now, the highest VVSG version that has had equipment certified against, so all the way through the process to certification, is 1.0. So after the software version is tested against the VVSG standards by the VISTL will submit a report to the EAC. The EAC reviews the report, and then assuming that the equipment has met the standards, the EAC can issue their certification. At that point, the software version can be submitted to our office, where we are required to review it, or where we can review it for state certification pursuant to OCGA 21-2-300 and OCGA 21-2-379.24. So once we receive the software installation, we begin reviewing it because obviously with voting system vendors like Dominion, they have customers all over the country. And the EAC is looking at it from a federal perspective. We have to look at it and make sure that the software works within the context of Georgia. And so now I'll pivot to the second item, and that's where Dominion 517 fits kind of within that timeline and that framework that I just laid out. So Dominion Software Suite 517 was certified by the EAC in mid-March, and then we got a copy of the new installation and began reviewing it. We began testing it to determine, among other things, the functionality of it, also the time and effort that it takes to update the equipment. In addition to these efforts, part of what we do, or what we can do, when we have a new software installation is obviously reach out to other jurisdictions around the country, our connections, our network, to figure out what their experience is with the software. And so we've been doing that as well. We also we're in frequent communication with the vendors to see what their experiences are as they communicate with customers and perform installations in other parts of the country. So since we're still working through this process, what we have right now is an incomplete picture of 517 because we're still reviewing it. So some of the information that we have so far, before I hand it over to Michael, we do know currently that the software installation does not currently work with the other components of the system that we have in Georgia. And when I say that, there were 2 counties in Ohio that upgraded to Dominion 517. One of them rolled back from 517 to their other version because they have an election upcoming in August. And what they found was that cards encoded by their electronic poll books, when put into the ballot marking devices, could not bring up a ballot. And so the ballot marking device could not read the voter access card. So we also know, and we're keeping track of this, the update has not been used in an election. The first election where it will be used in a jurisdiction is in Ohio in August. And so we're keeping close tracks of that. At this point, I want to state unequivocally we're committed to continuing the process of learning more about 517. Michael and his team are testing it. They're learning more about it. As Ms. McGowan mentioned earlier, we are planning pilots in several jurisdictions in November of this year, where we want to see how the software update functions from the beginning of the elections process to the end of the elections process. Obviously, with that, we need to make sure that the poll book is compatible by that point, which we're working with our poll book vendor to make sure that we stay up to date with the progress on that. But we're hoping that that's at a point where it is compatible for us to be able to run pilots. So for that, what I'm going to do at this point is hand it over to Michael Barnes.
Welcome, Mr. Barnes.
Good morning. Again, my name is Michael Barnes. I serve under Blake in the Secretary of State's office as his Deputy Director of Elections, and I work mainly with the voting systems that we use in the state of Georgia. We have begun the process of interacting with the Dominion Suite 517 to get a true understanding of what changes we may see between 5A, which is what we are currently using in Georgia, as we transition potentially to 517. The one good news, I think, from a voter experience, what a Georgia voter will see when they interact with a touchscreen, if we transition to 517, it's not a big change for what the voter experience will be. However, the majority of the changes are really in the back end of the system. Primarily within the election management system, and that is the system that builds the ballots. That's the system that counts the ballots. That's also the system that transfers the information from the election management system to the devices that are used, the BMDs, the scanners themselves. Because unfortunately, what we've called this process is potentially, we call it an upgrade. It's really not an upgrade. Even though it starts 5, it says 517, and we may use 5.5, this really will require us to fully rebuild the system. And that means the election management systems have to be completely rebuilt. The operating systems on those devices have to be renewed, updated to a different version. The back-end applications in which these applications sit have to be updated and replaced. So an additional amount of hardware has got to be procured for county use. And I'm not talking about touch screens and ballot scanners. I'm talking about the CPUs that are placed within the county offices that run the elections process, where the election project sits, where the ballots become tabulated. And we were not anticipating that initially when we began having discussions with Dominion about potential changes in the voting system. But that now is what we are seeing, is that we are going to have to look into going back to the legislature and asking for potential funds to upgrade some of the CPUs that are at the county level. There may be an opportunity to reuse some equipment that is already at the place, but I'm afraid we're probably not going to be able to do that. In regards to your BMDs, to your scanners, those are still available to be used with the new Democracy Suite, but that will require not just a simple install, an update, and hit update. We're going to actually have to break them all the way back down to the BIOS level. We've got to change a BIOS setting. We've got to adjust operating systems and then install applications. All of this process takes a significant amount of time per individual device. In the testing that we have done in our office, it takes with our staff about 15 to 18 minutes to go through a full installation process on a single BMD. For the installation on an optical scan unit, we're looking at about approximately 20 minutes, but there is some scalability in the optical scan units. We can have multiple optical scans going through an update process at a simultaneous period. The other issue we will have as we take on the process of potentially updating is the equipment is not all in one central location. It is spread out amongst 159 counties. So it will be an effort to figure out the logistics of whether the update process, it will require us to go to each individual county and do the work locally, or will we have to work with the counties to potentially bring equipment back to some sort of locational hub and do the work in a hubbed environment, and all those decisions are yet to be made. But as Blake alluded to, we are still in the process of learning more about 517, learning also what we will need to undertake to train our local officials on the use of 517. Is there any additional information that we need to make sure voters are aware of in regards to 517? There is some additional hardware that's available in 517 that we have not previously used. There is an upgrade to the ballot scanner that is available under 517 that does not currently work with the 5.5 option that we have. And there are some larger counties in the state that may be interested in potentially procuring this additional hardware because of its scalability, its ability to hold more information. So there's a lot of information that we're yet to really fully understand and get the full grasp of. So we want to move in a very meticulous fashion where we learn about this process, where we learn about 517, and they can then instruct county election officials to the best of our ability on what things they will have to do in order to execute elections successfully moving forward. So we are in the process of learning. I wish we were at a state where we knew everything about it at this point, but unfortunately we do not. The biggest surprise that we've encountered so far is the fact that the poll pads are not yet compatible with 517. The vendors are working together to resolve that, but we don't yet have a timetable on how long that may take. And I'm sort of thankful that we had not gotten too far out ahead of ourselves, because we could have really been in a situation where we could have been inadvertently impacted in an upcoming election. So I'm thankful that we are taking this meticulous approach at this point in time to learn as much as we can about 517.
From the board members? Questions?
For either one, for that matter. Let's sort of take a timeline here. And I want to make sure I understand, because I've heard lots of different things here. What is the drop, for want of a better term, drop dead point in which whatever system we have to have it for the 2024 elections? Because I realize, we're not talking about November. We have a general election in November. We have primaries and runoffs in May and June, May and June and July. We have special elections. We have a presidential primary in March. So in order to have this, whatever system we have ready for you, and then for you guys to do whatever you need to do to prepare for the election, what is the drop dead date?
It's getting very close, but I will try my best to give you a timeline answer. The scheduled presidential preference primary is early March.
Yeah.
We have to have ballots ready in the county's hands for mail-out distribution no later than 49 days prior to the election for UOCAVA voting purposes. That means that the election project that has to exist in order for ballots to be generated and ballots printed has to be completed. We always aim to have all election projects for an election completed, especially when there's a 49-day ballot window at 60 days prior to that scheduled election. So we're going to have all of the election projects for the state of Georgia finished by middle of January. In order to build those databases, election project files, we start receiving information from the counties in November of the preceding year. I believe that we will be obtaining from the Democratic and Republican parties somewhere around November who will be the candidates for their parties on the presidential preference ballot. Once that information is received, we're also receiving information from counties if they plan to have any special elections tied to the presidential preference primary. And we're trying to obtain that information at 90 days or sooner prior to an election so that we have adequate time to put that information, to organize the ballot, to provide counties ample time to proof the ballot to confirm that what is laid out is properly correct. And then once they sign off, we have to finalize it. We have to get the ballots to print. We have to get the election project packaged so it can be delivered to the county so that it can then be installed locally on their election management system so that counties can then begin the process of their logic and accuracy steps prior to the election. So the voting system needs to be in place for a uniform system of voting in the state of Georgia. We've got to be ready to go in December.
Okay. Mr. Chairman, could I ask another one? So along the same line.
Yes.
I'm curious, I'm not sure which one of you sort of commented about Ohio, but Ohio is also dealing with the same software updates. And apparently there was a problem with compatibility between the hardware and the software that Ohio was equally concerned about, but they seem to have, maybe I have it a little bit wrong here. What did they do in order to fix that compatibility problem so that they could have 517 in place, or at least by a pilot program by August? So what did they do in order to fix that?
What the various counties in Ohio are doing, and Ohio is a different system than, of course, what we do in Georgia. Georgia's a uniform system where every county is using the same type of equipment. In Ohio, it's jurisdictional. Each county decides what they use to service their voters. In those Ohio counties that have been transitioning to 517, there are multiple poll book vendors in play, but there are 2 poll book vendors that are unable to currently work with the 517 model. That's No Ink's Poll Pad, and 10X is the other vendor who is currently unable to work. The jurisdictions in Ohio, what they have opted to do, one county, because they wanted to still maintain the use of their poll pads, or actually their 10X devices, have decided to downgrade from 517 and actually go back to their 5.5 level on their voting machines, so that they will be able to still use their poll pads to manage the voters as they come in and participate during the election. Another county that has that same dilemma of, we have a set of poll books that are not working currently with our 517 environment. What that county has opted to do is to not use their poll pads or their poll books for this election, that they are going to go through another mechanism of preparing the voter access cards that will be then given to the voter that will allow them to interact with the machine. So they are using a different tool to create the voter access card that will be presented to the voter, and they are not using their normal poll pad procedure.
How many counties in Ohio are using the Dominion system?
The last count I got from the vendor yesterday, I believe that there are 7 counties in Ohio that have now upgraded to 517.
And of those, how many counties are there totally?
I'm not aware of the total number of counties in Ohio.
Do you have a good estimation?
It would be nothing but an estimation, and I would hate to be inaccurate on that. They don't have 159 counties, I know that. 88 counties, thank you, 88 counties.
You're off by one, but you're forgiven. How many updates has Dominion offered to Dominion users since we first bought the system for use in our elections?
In checking what is currently federally certified under the Dominion under the Dominion brand with EAC, I was checking yesterday. I believe there are 4 different versions of the 5.5 series. There's A, B, C, and D. The newest version is 517.
And does 517 incorporate everything that was in the prior updates?
It incorporates a lot of various things from when the last time Dominion had put a suite together for EAC certification. There have been hardware enhancements. There have been statutorial changes in elections in our state, but also in other states that they serve. So vendors tend to put those type of items into their suites so that they can expand their customer base potentially.
And of these EAC certified updates, how many of those did we, Georgia, incorporate onto our machines?
We have only stayed with the 5.5A series. There has been, we went through an update, which was a true update of one of the applications within the election suite in 2020, and that was on the BMD touchscreen, that we had to go through an application update in order to facilitate a 2-column screen when we had 21 candidates for a single contest. And so we had to actually upgrade or update our version number from 5.5.10.30 to 5.5.10.32.
Yeah, I'll try to remember.
Yeah, if you do, congratulations. That's
in these updates, ones that weren't implemented in Georgia, and in 5.7, if you can answer this, do any of those address security and making the system more secure?
the 517 application, Democracy Suite, was developed in response to those concerns that have been raised over the last 2 to 3 years.
And do you know with more specificity what the concerns are that are addressed in 5.17?
I'm afraid if I start getting into some of those answers that I'm opening ourselves up to talking about things that we would be unsafe to disclose.
Or can you do it in a more general way?
There are basically the applicational backgrounds, the backbones of on which the applications are being reinforced and enhanced. And I think that's about as far as I can get.
What does reinforced and advanced mean?
This gets into the coding that you put in place within applications to make applications more secure.
Okay. And is that more secure with respect to internal or external threats?
It's a combination of both.
And is that being implemented in 5.17 throughout the system? For everybody who uses it, that's being offered?
Yes.
Okay. Is it your sense that this will be a good update, that will be good for the machines that we use in Georgia?
The process of learning about it is absolutely a good step to learn more about. I have been around a lot of voting systems in my time, and sometimes when a new version comes out, it's best to be cautious because there might be another new version coming right behind it. Because sometimes that thing that we thought that fixed everything turns out it got close, but not quite. So I can't say with absolute that yes, this will be great, because it is an element that we need to learn more about it before we move too quickly.
Just one more question on timing. If for the presidential preference, you have to be able to build ballots and the system be available for voters, that has to occur by December, did you say?
Yes, sir.
Okay. Is it possible to do all the things that you described were necessary to do the investigation and state certification and be comfortable with the system? Is it possible that that could be done by December?
It's really important for us to see the use of any update to the system, any upgrade, any change to the system in a real election environment. Before we transitioned to our current system, we actually put the system through a piloting effort in 2019. And we did that in an effort to learn not only how to use it, but also how to train officials and train voters on how to use it. And it's very important to have those real election circumstances, because things happen in elections that sometimes we don't anticipate. And it's not when the election goes perfectly, how does it react? It's how does it react when something happens that we weren't expecting? And that's the real life experience we gain through a pilot. And with the pilot scheduled for November, of course, as long as the poll pad application gets in line and we are able to use it, if we're not done with a piloting operation until November, I don't know how we could then transition to a statewide implementation in 30 days.
Okay. Any other questions?
Yeah, going back, if I may, Mr. Chairman, going back, why can we not use Ohio as the piloting aspects?
Well, we definitely use other jurisdictions and learn from their experiences. The one thing with the Ohio experience, Ohio and the counties that are updating to 517, they actually don't use it as a BMD client. They use it as a DRE, a direct record electronic system. So it's the same touchscreen, but what the voter does in Ohio is they interact with the touchscreen, and then the ballot is printed out onto a little tape that's attached to the touchscreen device. The voter looks at the tape, looks at the selections on the tape, and then if they accept it, the tape rolls up and that becomes the vote of record. So they're using a compartment of 517, but it is not the same thing that we would be using in the state of Georgia. So we can learn a lot, but it's still not in the same environment that we would be using it.
Okay.
Just one question. Do you have an accurate estimate of how many person hours it would take to do the full upgrade?
I don't have an accurate estimate as of yet, because again, not understanding yet how we would handle the logistics. It will take a tremendous. I started doing some calculations on man hours, but unless I know if I've got to travel to the county or if they're coming to me, it's hard to come up with a good estimate at this point.
Oh, yes, okay, worst case scenario.
Worst case scenario.
Having to go out to 150.
Worst case scenario, I do have experience of us having to go out in the counties and do updates on the pre-existing system, but that update was a much quicker installation process. This is a much bigger rebuild. In those exercises in the past, it was always a 6-month operation. With this process, I honestly am thinking it's probably going to be closer to a 9 to 10 month operation.
So that's based on personnel available?
It's based on personnel available, yes.
And when you do this, do you hire supplemental personnel for the rollout and then on a part-time or a temporary basis?
The leadership in each agency determines what they think is the best course. In previous installations under different administrations, we used actually a contracted source that had a relationship with the Secretary of State's office for installation purposes. I don't know of yet how the Secretary of State's office might want to facilitate this installation process because of what will be involved. My division, of course, would be involved heavily. I have 7 to 10 people that report to me, but we're going to need a lot more than that. I know that we have made some inroads into working with the technical colleges of Georgia to maybe use some personnel from the technical colleges of Georgia to help us with this process, but those discussions are in the very preliminary state.
And I think you said that the system requires new CPUs to be used in each of the counties. And it doesn't work without the new CPUs. So, I mean, you need new CPUs for it to work?
You're going to need the CPUs because one of the elements of federal certification is that it actually gets down to the hardware level, where it says this type of device is, this server, this what was classified as like an express server, is on a particular type of Dell machine that has certain workings there within. So yes, we're going to have to make some adjustments at the CPU level.
And ultimately, would the counties have to pay for the new CPUs?
That is an element of the Secretary of State's office having to determine what that is going to be. I can't speak to that at this point in time.
Do the counties have at least an order of magnitude of maybe what that equipment costs so that they can go?
Not at this point.
Do you have a thought on that?
I don't have an order of magnitude of what the cost would be at this point, but it would not be insignificant.
Well, that's pretty ambiguous, but I understand. Insignificant might be different things to different people, but for counties, I think that significance is a pretty low level. Okay, thank you, appreciate it.
One last question from me, Mr. Chairman. Talk about worst case scenario in terms of time. Let's take the best case scenario. Let me ask you this practical. Everyone brings all the equipment to the World Congress Center, and you're able to do all of the necessary upgrades to the equipment at one location. Does that shorten the time period you need? In a centralized location with all the people that you could possibly need, it's going to shorten the time. But possibly one way we've sort of done this before,
We did this in 2020 with the initial rollout, and we went through in a central warehouse 30,000 devices that were installed and then acceptance tested by the state and then packaged and distributed out to the counties. And in that central warehouse environment, it was still 6 to 7 months.
And I assume in order to get the machines to a central environment, that would be a cost that would have to be incurred by the county?
I suspect there would be some county costs. What those county costs would be, how much they would be, I do not know.
I understand. Dr. Johnson?
Michael, does this upgrade elevate the certification to BVSG 2?
No, ma'am, it does not. 517 was certified. 517 was certified under the VVSG 1.0. At this point in time, I believe there's only one voting system that's currently in review by the Vistals at the 2.0 state.
And could we utilize the upgrade without using poll pads?
That would be a decision that would be made by people above my pay level. But could it be possible to do that? It could be if you chose not to use poll pad for voter access card activation.
Okay. And does this satisfy the CISA mitigation recommendations?
The software package was worked in response to those. I will just say that that's what it was brought forward based upon.
Okay. And this, is this part of what will be presented as far as health check? Of the computer, of the voting system?
Don't ask me.
Oh, well, I thought, Blake, were you going to speak to the health check?
Okay. I can answer some of your questions on the health check. We are currently in the process of visiting all 159 counties in the state to sit down with their election management systems that are currently in place and to do an assessment on those CPUs to determine if they are ready and basically in a health way for the upcoming elections. Do they have the applications that they are supposed to have? Not only do they have the applications, do they have the right installation of those applications present? Is the system connected as it should be? Is it working? Is it working in the sense of where it's sharing information across all of the CPUs that may be connected to that system within the county? We are also inspecting their voting equipment and assessing whether on what has been installed on the equipment is what's supposed to be there. And not only is it installed properly, but also is it functioning properly? Is it acting as it should? Is it taking the acceptance of an elections project file? Is the interaction of the voter as expected, as should be when you put a test scenario in? Are ballots being produced as they should? Are those ballots then being scanned and tabulated properly? So we are in the process of visiting all 159 counties. I think as of yesterday, we've completed visiting 8 counties. So we've still got a lot of work in front of us, and this will be ongoing through the rest of the calendar year. We are going to try to get as much done before the end of August as we can, because we know we have a lot of jurisdictions that will have ongoing elections that they must be preparing for in September, October, November. But those jurisdictions that don't have an elections will continue visiting those counties, and it's our objective to complete all 159 counties by the end of the calendar year.
Just one final thing on that answer, and I don't know if it was Mr. Evans or you, but I think there was a statement saying that the machines had nothing added to them. I don't know if I heard that correctly, but.
Well, what we are looking at is the status of their equipment, and we have the ability to know what's supposed to be there. And we are making sure that what is there is what's supposed to be there.
Meaning that if something is not supposed to be there, you would address it?
Yes.
Okay.
So you'll do a virus check?
We are checking the system to validate that what's in the system is what's supposed to be there. Yes, ma'am.
Okay. and review of like intruder log or something?
Yes, ma'am.
Mr. Chairman, good questions lead to more questions. These health checks, or whatever you want to call them, in terms of our system, given the fact, assuming for a minute we do not do the upgrade to 517, has CISA weighed in on whether or not the remedial efforts that we are taking to attempt to ensure our system is sufficient? Has CISA weighed in on that?
Can you say anything about CISA? To our knowledge, CISA has not made any statement on that.
Is it appropriate for us to make that request to CISA to see if it's if it's adequate in their opinion? Is that an appropriate inquiry to CISA?
So we were reached out to by, I believe, the EAC field team and had an initial meeting with them. And there's a chance they might come to kind of observe. Michael, do you have any more details on that? I know it's kind of early.
Thank you, Blake, for reminding me. We have had a discussion with the EAC Field Services Office, and have invited them actually to come down to Georgia to go with us out as we're doing some of these health checks so they can see what we are doing in an effort to make sure that the system in Georgia is ready for the elections that are oncoming. So we feel like that is an opportunity for EAC to be involved to see what steps we are taking to make sure that Georgia elections are ready.
Yeah, I guess my point is that I think it would reassure a lot of folks if either EAC or CISA or some other agency other than the Secretary of State's office, somebody could validate what you are proposing independently. I'll leave it up to you guys to figure out who.
I have a question. In response to Mr. Lindsay's question, I think you were answering what can I build, and you backed out of an election. You ended up with a 30-day period between November and December. I think you were answering the question, what can I build, what can we build? But as I also hear, this is actually not going to be ready to be put in place until the Secretary of State and the General Assembly figure out how we're going to pay for new CPUs, which you said is not an insignificant number. So there is no way to do it November to December. There's no way to do it in December of this year.
I guess that's my advantage is I don't have to figure out the money. And there is a money compartment to this, and that's again for people above my pay grade to be figuring out what we can or cannot do yet.
I wanted to go back to your description of some of the upgrades and to talk about specifically some of the scanners and how that might impact some of the larger counties. Now, my assumption, which please correct me if it's wrong, is that some of these upgrades would allow the larger counties to use a single scanner for early voting because it will accept more ballot styles.
Potentially. They have increased the ability to hold more information. However, we want to be able to see, is it still enough to hold what we would have to do in Fulton County, for example. We feel like it is, but when you start getting into a general primary ballot that's 18 inches long, in some cases it's 2 pieces of paper that are 18 inches long, and all the information that goes into that, when you create the digital image that we have to collect along with it, they say that it can hold it. I'd like to see it and test it out.
Now, is this a hardware upgrade in addition to a software upgrade for this functionality?
That would be a whole new piece of hardware. What we use in the state of Georgia is classified as an ICP, Image Cast Precinct. The new piece of hardware that's available in the Democracy 17 suite is an ICP2. Image Cast Precinct 2. It's just a different model. It maintains information in a different type of storage media.
And can I is it an accurate guess that it would not be, could not be retrofitted to be compatible with?
Unfortunately, it is not compatible with our version.
Okay, thank you.
Any further questions? To both of you, this has been really, really helpful. And I think it's probably been helpful to everybody who's listened to it, is to understand what it is rather than just referring it to the update, to have context and facts to evaluate what the update is I found personally enlightening. Probably some of the things that we ought to do maybe more often, but thank you for coming. Thank you for agreeing to do this. And I think it tells me that maybe we ought to be doing more of these educational sessions. But thank you. All right, now we will move on to item 3, where we are going to consider violation cases recommended for letters of instruction or referral to the Attorney General's office, which is a continuation of what we were doing at the end of the meeting yesterday. And we'll begin with case number. That was not for you. That was. Case number 2019-43, Paulding County enclosed space violation. And can we have you all get settled? If we would like to have a report on that, please.
Good morning, Board and
Good
Chairman.
morning.
All right. So we'll start off with case number SEB 2019-043, Paulding County enclosed space violation. On November 5th, 2019, an SOS employee was observing the pilot use of the ballot marking devices at the Paulding County Watson Government Complex. She observed 3 citizens in the enclosed space looking at the BMDs. She took a few photos of the individuals. Once the investigator viewed the photos, he identified those citizens that were in the enclosed space as Richard DeMillo, Marilyn Marks, and Rhonda Martin. Deidre Holden, the Paulding County election supervisor, advised that the 3 entered the enclosed space without permission, and they never identified themselves to the poll manager. Gail Combs, the poll manager at the location, stated that the 3 individuals went into the voting area, and the male, Mr. DeMillo, took photos of the equipment. She said that the 3 did not ask for permission to enter the voting area, and she did not know that they could not be in the space. She later identified the 3 via photos as the subject inside the voting space. The investigator interviewed all the poll workers, and all stated that they did not give the citizens permission to enter the enclosed space. The investigator reached out to other election precincts in the surrounding counties. For Lindia Kennerly, the poll manager at the Smyrna 1A precinct at Argyle Elementary School indicated that she had issues with two females. She described them as a blonde-haired woman and a dark-haired woman. According to her, the dark-haired woman identified herself as a poll worker, so Mrs. Kennerly allowed her inside the enclosed space. She asked her for her credentials, and the dark-haired woman did not have any. She told her that she should have documents and identification if she was a poll worker, and that she instructed her to sit in a different area. The investigator sent Kennerly a photo, and she identified Marilyn Marks and Rhonda Martin as the females who came into the polling location. She stated that Mr. DeMillo never came into the enclosed area. All three citizens denied going to the Argyle Elementary voting location. So based on this, we determined evidence suggests that Gail Combs, Deidre Holden, and the Paulding County Board of Elections and Registration violated Georgia Code 21-2413H when they allowed the citizens to enter and remain inside the enclosed space at the Watson Government Complex when they were not voting or acting in the capacity of a poll watcher or poll officer. It indicates that it shall be the duty of the chief manager to secure the observances of this code section, to keep order in the polling place, and to see that no more persons are admitted within the enclosed space Also, poll manager Gail Combs allowed Marilyn Marks, Rhonda Martin, Richard DeMillo to enter and remain inside the enclosed space at the location when they were not voting or acting in the capacity of designated poll watchers. Also, there's evidence to suggest that Marilyn Marks, Richard DeMillo violated Georgia Election Code 21-2413 when they entered and remained inside the enclosed space when they were not voting or acting in the capacity as poll watchers or poll officers at the Watson Government Complex. And then there's also evidence to indicate that Rhonda Martin violated 2 counts with the violation at the Watson Government Complex and at Argyle Elementary, based on the statements of Ms. Connerly.
All right, is respondent Paulding County Board of Elections and Voter Registrations present? Would they like to be heard? Yes, please. Well, I tell you what, it might be, since he's all set up there, this microphone should work once I turn it on, which is, try that.
Okay, thank you. Thank you for having us here. Thank you for your presentation. I'm Deidre Holden. I'm the Elections Director for Paulding County. I do want to say something before I go into what we're here about. I want to commend this board for reaching out to counties and getting our input, because I've been doing this since 2004 and I've never seen this happen. It is important to us as election directors and officials to know that you want to know what we do. So thank you. On to this case, I want to say this. In 2019, Paulding County was the largest county to be a part of the pilot using the new voting system. We were excited to do that. On that day, we had the Secretary of State and a lot of his staff there, and media from all over the United States. This was a big deal. I was not in the area when Ms. Marks came in. I was notified by a member of the Secretary of State staff because she was standing there at the entrance of the enclosed space. I think one of the arguments you're going to hear is there's no such thing as an enclosed space, and I disagree with that. You may have photos that have been submitted to you. The Watson Government Complex is where our office is located, and we use a very large area to vote the masses of voters that we see. Our area is petitioned off. It's very clear that there are voting machines in there. We also employ what we call a machine host that stays in that area for the entire duration of the election. So those machines are being constantly watched. If a voter has a question, they raise their hand and that machine host goes and assists them. You know, I've always been one that believes that we should learn something new every day, and when we stop learning is when we fail. Thankfully, I've never had to identify an enclosed space. But when this happened, you better believe I identify enclosed spaces now. Once that happened, we post signs at all of our polling locations identifying what the enclosed space is. So that was a lesson learned. I believe that in 2020, when we went through the pandemic and we finally got to have an election in June, at this point, the Secretary of State was making enclosed space signs and issuing them to every county in the state. We haven't had this issue since 2019. I understand the excitement about this system. I understand people wanting to see it, but there are boundaries. There are lines that you don't cross. Had I been out there, I would have been able to assist Ms. Marks and her friends that were with her, but I do want to say that we do now. We have put procedures in place where it is very identifiable of where the enclosed space is. Do you have any questions?
Would you find it more helpful to have these definitions of enclosed space articulated more clearly in the regulations? Because under the regulations right now, the rulemaking that was done through this body, it says it shall be enclosed with a guardrail or barrier. Would it be helpful for your implementation and enforcement to adjust that?
Absolutely. I think there's a lot of gray areas in the code and in the rules that need to be more defined, so we'll know, and so that the voters know. That's who we work for, and we want their experience to be a positive one when they come to any polling location. So I do think it needs to be better defined.
Thank you.
Thank you, Mr. Chairman. I've been out to Paulding County, and I've toured their facilities personally, and they run a first-class shop out there, and I was very impressed with their diligence and their zeal for elections. So one of the things that kind of concerns me about these cases sometimes is the counties will report they've had this problem, and then we turn around and say, our answer to this problem is we're going to prosecute you.
Yeah.
And so I think there's a little unfairness there. And so kind of for that reason, the defendants, the other respondents in this case is all together, but we're kind of doing them one at a time. But the respondents in this presented pictures of Watson, and I looked at those pictures, and that's a very well-defined enclosed space with a very well-defined barrier. I mean, it's a tiny little passageway with blockers.
Yes.
And I was a poll watcher for many years, so I'm funneling all this through my knowledge as a poll watcher. I've been in hundreds of precincts. And just for the people out there listening, my practice that I never had a problem with in 20 years, 25 years maybe, was I would walk up to the poll manager with my ID, identify myself, and say, where would you like for me to stand? And if I didn't like it, the statute says if you have a problem with the poll manager, you report it to the election superintendent.
That's right.
So for everybody out there, if you want to know what an experienced poll watcher has as advice, that's the way to do it. So I would prefer that we dismiss the charge against Paulding County. But if the board is not inclined to do that, I think a letter of instruction of saying, please be more diligent in keeping people out of the enclosed space and don't let strangers in the enclosed spaces is warranted. But I'm very sensitive that we not establish a practice where we punish people who report violations.
I would like to comment to what you said, Mr. Mashburn. I appreciate the passion that Ms. Marks has. I look up to her. She's a wonderful person. And in no way in Paulding County would we ever discourage a poll watcher or an observer. In fact, we invite people to come watch the process because people don't understand elections until they see it on the backside. So we want people to come in and watch that process. We want people to be interested. And, you know, I don't think there was any ill intent of Ms. Marks and the people that were with her. I think she was just very interested in this new voting system. But there again, I don't like to be blamed for something that really didn't happen. It happened that they went in there, but to say that it's my fault or my board's fault, we've done everything we can do. We've trained people, and I just think that a better definition and also better training for people who are going to be poll watchers and who are going to be poll observers to say, look, you need to follow these protocol and there won't be any issues. So I appreciate what you said.
Further question, you said that you've added new marking?
Yes, we made signs. We immediately made signs and started posting them in all of our polling locations that identify the enclosed space. It says this is the enclosed space, and we cite the rule in the code.
So with respect to this enclosed space at the Watson Community Center or
Watson Government.
Center, did you place the signs at that entrance where people would enter that had these?
At Watson, that is our largest early voting location, but it's also one of our largest precincts. So after this occurred, and we realized, look, we want people to know what the enclosed space is. Watson has 2 enclosed spaces. We have one that we have for our elderly and disabled, so they don't have to stand in line for a long time. And then we have the larger enclosed space for just the regular voters. So yes, signs are placed at the entrance before anybody walks in and breaches that area. It says, this is the enclosed space.
So you didn't redefine the enclosed space, you just put signage to show them.
Absolutely, yes, sir.
And second, did you freely let citizens that were interested in this walk in and out of the enclosed space?
No, sir.
Did you ever see anybody milling around to look at the operation and to observe it?
No, sir. I was not out there when this happened. I had, 18 more precincts I had to deal with that day. But I will say, with the Secretary of State staff being there, it was just recently brought to my attention. I was told that this was going to be a state case, not on a county level. But there again, I see, where Ms. Coombs had to be brought in place because she was the poll manager and it happened while she was there.
Right.
But, when we have observers, they're very polite. They come and they tell us they're there to observe. They don't interfere with the election process. If they did, I would deal with it. But I think that people know their limits. Poll watchers have more restrictions on them than an observer, and an observer can just come in and watch everything, and we want them to. But I was not aware that this happened, but we've never had this happen in any of our polling locations or early voting.
When you say observer, what do you mean by that?
anybody can come in and watch the process.
From where?
From, I mean, my neighbor could come in and say, hey, I want to watch what's going on, and we have to allow them. And I think that's good, because that shows that they're interested and they want to make sure we're doing our jobs and they're holding us accountable. But a poll watcher has restrictions. A poll watcher is there to make sure the election is flowing as it should. They're there to identify any issues and bring those to our attention as well. An observer is just there to make sure, well, they're not really there to make sure of anything. They're just watching. They're just observing what's going on.
And can an observer walk around the areas where people are voting just to see what's happening?
They can walk around. Most of our observers just come in and sit down, and they can sit in an area where they can see everything that's going on. They don't talk to the voters. They just watch. They just watch the process.
But can they watch and walk? So
Can they walk
can a
around?
watcher, somebody who's an observer, let's say you have 3 different areas of people that are voting using the ballot marking devices. Can they kind of walk around there to see how people are using them and what they look like?
We don't let them go close to our voters, because we don't ever want to give up that secrecy of their ballot.
Right.
They can watch at a distance. I think 6 foot is a good distance. We don't let them hover, but most of them don't want to go into that room because they do know people are casting their vote there, and they respect that privacy.
So are observers watching the process from outside the door, or are they actually coming into the enclosed space?
I don't have observers going into the enclosed
Okay,
space.
I misunderstood that. Okay,
Yes.
thank you. All right.
Any
Any
more
other questions for
Thank you so
Ms.
much.
Holding? Thank you very much. Is Ms. Combs here?
Yes, she is not here.
Okay, thank you. All right, how about Ms. Marks and Mr. DeMillo?
Good morning, Chairman Duffy. Thank you, Bruce Brown. I am representing the respondents in this case and in the following case. I will address the Argyle Elementary School allegation first. That is the allegation that there were 2 women, one dark-haired, one lighter-haired.
Wait a second. We need to close, can somebody close that door? Oops. No, he's just, I'm sorry. And can you speak up a little bit?
Sure.
That's good.
I'll deal with the Argyle Elementary School allegation first, and that is the one where that is against Miss Martin, and she is alleged to have been in the enclosed space and also next to Miss Marks. The fact that that allegation got to the board as busy as it is in dealing with the crucial matters of Georgia election security as it has this morning is of some concern. That allegation is completely false. My clients denied it to the investigator. The investigator undertook a separate investigation to try to find some corroborating evidence, including looking at license plates at Argyle Elementary School, could not find any. And then he says in his investigative report, I couldn't find any evidence that my clients were there. Even though there's no evidence, here we are 3 years later, 4 years later, dealing with it, with our time, with your time, it must be dismissed. Ms. Marks was in Charlotte, North Carolina at the time. I have, and I will give them to you if you like, a printout showing she was in Charlotte because it was election day, and she has a Mecklenburg County voter history. We told all of this to the investigator. They were not there. And still, for some reason, these people who happen to be also litigants against the state election board, this complaint persists, even with everything we've written about it, to the board. So it needs to be dismissed. Now, the other one...
Are you saying that the state election board motivated the investigators to investigate Ms. Marks
No.
because we're defendants in the case?
No, but it needs to be dismissed.
I understand that.
Okay. Now, on the second one, about the enclosed space. It's an interesting issue. We've written, hope you have the memo that we wrote on it. But there was no enclosed space at the Watson School. At the Watson Government Center. What the enclosed space is, and this is defined by statute, is the space around the election, around a barrier around the voting booths. But the features of that are that you have to be able to see. It can't be a physical barrier like the one she's describing. What she's describing is the voting room. That's what the law calls the voting room. And you see the pictures of the very big barriers. That's the voting room. That's not the enclosed space. And if you look at the law, as Judge Duffy, you mentioned, first thing to do, just look at the law. The law says the enclosed space is something within the voting rooms. It's not equated with the voting rooms. It also says that the enclosed space has a guardrail or barrier. There was no guardrail or barrier.
Do you agree? I'm sorry to interrupt, but do you agree or disagree that in your picture, you show the large partitions? Do you agree that or disagree that that's a barrier?
It is a barrier. That's the voting room. And in fact, the witnesses themselves refer to that as the voting room. The law refers to an enclosed space as something within the voting room. It's very clear on that.
Is it impossible for the voting room and the enclosed space to be the same thing?
It is, because otherwise the laws would make no sense, Your Honor.
Is it possible that the voting room and the enclosed space can be the same space? Or you say that the law requires there to be a voting room and that the law, even if it's a small space, you then have to designate some portion of the voting room to be the enclosed space?
Two answers to that. One, sort of an academic answer, is that it looks like the law of the statute is distinguishing between voting rooms and enclosed space because it says enclosed space is a space within the voting room. Okay, that's the first point. And so I would caution, if you do provide a better description of the enclosed space, that it not be contrary to the statute, which makes that distinction. Okay. However,
let me interrupt you there on that point.
Sure.
One of the things, if we had a Chief Justice named Namias, and he was very famous for this formula that I'm about to give you. He's retired now, but I read a lot of his opinions. He always said this. So if you say the voting room, the enclosed space has to be within the voting room, and you say they can't be the same, what is your definition of within? 1 inch, 1 millimeter, 1 centimeter, 1 nanometer, 10 feet? What's your definition of the requirement of within?
I don't care. They need to be different, or else the legislature wouldn't have said that they're different.
All right, and you're basing it on the fact that they're different by one has a requirement of visibility and one does not.
Two things. One is the statute says that the enclosed space is a space within the voting room. Okay? Now, I think a fair reading of that, if you could read that and say, all it says is within, that's not inconsistent with it being the same thing. You could say that. I don't think that's a reasonable interpretation of it. Okay, but the other point, I think is more important, this is your second point, is that the law also provides that the enclosed space cannot be a visibility blocking barrier. And that's the important point. Because as the other speaker remarked, it's crucially important for observers and for poll workers and for everybody to be able to observe what's going on in the enclosed space without interrupting the voters. So that's the point. So the way the law is makes a lot of sense, and that is you've got the voting machines, and then maybe 6 feet out from that you have some sort of barrier, but it's not a physical barrier you can see. That's why it says guardrail or barrier.
Well, let me continue to interrupt you. I'm sorry I keep doing it, but
I'll answer your questions, so that's fine.
Traditionally, whenever I was a poll watcher, every poll watcher I knew always treated the check-in table as the barrier because there was somebody sitting there and you had to get the permission of that someone to go any further. Are you saying that the check-in table cannot be a barrier?
The rule says enclosed space shall mean that area within a polling space enclosed with a guardrail or barrier, closing the inner portion of such area. So to get back to your question about Justice Namias, enclosing the inner portion of that area would indicate that it is a different area, so that only such persons as are inside such guardrail or barrier can approach within 6 feet of the ballot box.
Okay, so if we have a table, the check-in table, and a person there saying nobody goes past this point, and we got to make sure the machines are at least 6 feet away from that point. Your argument is that the traditional use of the check-in table is not a sufficient barrier, is your argument, right?
I don't need to make that argument because here the check-in tables was right in the middle of the voting room.
Are you talking about Argyle or Watson?
No, Argyle, we weren't there. I don't know what was at Argyle.
Okay.
None of our people do because
All right,
they
so
were
we're talking
never
about
there.
Watson, okay.
Talking about Watson. In Watson, the check-in room was in the middle of the voting room. Okay. And if that were the barrier, then the voting room itself wouldn't be the barrier. Here's the thing, is that there was a big physical barrier that you described. It's about 8 feet. It blocked visible access to the voting rooms. It's very clearly a barrier. If that is the enclosed space, it clearly violated Georgia law because you have to be able to see the voting machines from the members of the public. That's what the county manager just described, is that the public has to be able to observe it. Under the law is very clear, is that you have a barrier, an enclosed space. 6 feet's good, but that doesn't block physical access, and that's within the voting room. You can tell, and getting away from sort of the academic, or I don't mean academic in the sense that it's not important, but just on the interpretation of the law.
No offense taken.
Yeah. If you look at what the allegations are in this case, is that my clients went into the voting room. Okay, that's what they said. They didn't say enclosed space. That's what the investigators are putting on top of this. Okay, but Coombs and also Hausman said they went into the voting room. They didn't say they went into the enclosed space. It's the investigator that put that gloss on it. There wasn't an enclosed space. In fact, the representative admitted there was no enclosed space because in response to the questions from the board, she said after this, we started putting up signs or whatever denoting the enclosed space. So there wasn't an enclosed space there. So,
I understand your argument.
okay.
Mr. Lindsay has a question.
And I appreciate the legal back and forth, and in terms of the long-term figuring out possible rules. Let me ask a more factual question. Where exactly were they?
They were in the voting room.
They were in the voting room?
They're in the voting room, Mr. Lindsay.
That's fine.
with-
I just want to know where exactly they were.
But they were in the voting room with members of the press, with Ms. Hausman, with Steve Fowler. All of them were there.
Right.
They are the three that are being prosecuted. The photographer would have been, if that was the enclosed space, the photographer would also be a perpetrator. So the Exhibit A would be taken by someone who was a perpetrator, if that was the enclosed space. It's not the enclosed space. None of them were violating the law. Steve Fowler wasn't violating the law, Liz Hausman wasn't violating the law, and neither were my clients.
I just want to know physically where they were. Thank you. Appreciate that. And I heard the rest of the argument.
Didn't mean to answer
No.
your question.
I'm just trying to figure out where exactly they were
Sure.
in light of the discussion you had with
Yeah.
Mr. Marshman.
And so that is our response. But I'd also like to emphasize that there's no, and this is very important, and you heard the nice remarks that she made about Ms. Marks and Dr. DeMello and Ms. Martin. You know Ms. Marks. Richard DeMello is one of our main experts in the Curley case. He is one of the leading experts in the country on cybersecurity. He was praised by Judge Totenberg in her opinion that led to the pilot that this was a part of. As a part of the pilot, one big question that Judge Totenberg had was, can they do, you heard the difficult process that we're going to undergo this next time. of converting to the next software. Well, when we got the DREs enjoined, the question was, will the state be ready to put in the BMDs? This is back in 2020. Judge Totenberg was very concerned, but one of the things that the Secretary of State said, as you heard today, was they were going to do a pilot. And Paulding County was one of the pilot locations. That's why everybody was out there, including the expert, our expert, and including Ms. Martin, also an expert, and Ms. Marks. Those were the people that were out there. These are professionals, they're highly respected, and there is no suggestion that they did anything wrong. They didn't touch any of the equipment, they didn't talk to any of the voters. There's no suggestion that they were in any way rude or anything else. And so, particularly given the propriety of their actions, the importance of their cause, and the absence of any evidence that they were in an enclosed space, we ask that be dismissed today.
And they were there as an observer, right?
They were there as observers.
Mr. Chairman, would it be appropriate, I want to ask a question to our investigators.
Let me just ask one more fact question. Did anybody within your clients take pictures of anything?
Yes, the panorama that you have in your material, I think was one of our photos.
Taken on the day and
Oh, we did. I'm correct. I thought that was one of ours, but that was from the Secretary of State's office. So no. Answer is no. Thank you.
would that have been okay for them to take pictures?
Yeah. Well, no, it
Can
depends
any-
on what it's of. Right.
Pardon me? I mean, can anybody who's an observer or a
We're-
poll watcher take pictures?
Part of my difficulty in answering is the law has changed on photography, and so I don't want to comment on that. And some of them are actually being challenged. Some of the laws are being challenged in a separate lawsuit, so I don't want to
Well,
speculate
we've
on
got,
that.
the law at the time of this incident, what was it with respect to pictures?
I do not know.
Okay. I'm sorry.
No, I can wait. I just wanted to see whether or not my investigators, the Secretary of State's investigators, can you confirm that, Mr. Brown has told us that in addition to his clients, there were other individuals there as well, including Ms. Hausman, and what were the other ones, Mr. Brown? Mr. Brown, who were the other ones? He said Ms.
Some
Hausman.
reporter and some camera.
Reporters?
Were they also at the same place where the Ms. Marks and her group were?
From the reports, they were at the location, however, not in the same places that the three individuals were. There's photos of them right near the voting machines. The three individuals.
Were the
Here.
Ms. Hausman, I don't mean to call her out necessarily, but were those individuals also in the proximate location, sort of in that general location as well? I'm just trying to figure things out here.
He's one of the things I'd
Let
like.
me ask him real quick, and then I'll let you respond. No problem, I just want to.
Yeah, you can't discern that from here, but the photos that were taken were of the three individuals that were near the voting machines, very in close proximity within probably, just looking at the photos, maybe a foot of the voting machines, maybe even closer.
Is anybody other than the three people in the picture?
Okay, this looks like Mrs. Martin by herself in one. Mrs. Marks by herself in another picture.
Well, we've not seen those. Could we see those? Well, just show us the pictures.
To clarify, photography can take place in a polling place at the discretion of the poll manager.
So you'd have to ask permission.
Yes. while persons are voting.
Ms. Holden, do you have some pictures too?
Yes, sir. I would like to say that Ms. Houston, she would have been permitted. Since she is a member of the Secretary of State, she would have been permitted because she's considered an election official.
Not at that time, though. She was, I don't believe she was at that time, 2019. She was still in the county.
She came there with the Secretary of State and was introduced to me as a member of the Secretary of State's office. But she did take the pictures. That's how I knew about it. I did want to show you a picture that we have of the area. Is that permissible to show you?
I guess we're looking at pictures, but yours happens to be on a device. Well, let us look at these first.
Okay.
Can I just ask you, this is in Exhibit 42 in the file, is that Mr. DeMillo?
Yes, Your Honor, and you're looking at things that we've asked for in advance of this hearing, but did not get. That is Dr. DeMillo. He's here. if you'd like.
Tell me what he's holding in his hand? What does that appear to you to be? Well, looks to me like a cell phone. In fact, there's a little camera up in the...
Yeah, could have been a cell phone. To get back to the allegations, the allegation isn't, as I think the investigators will confirm, is that the violation is not standing too close to a voting machine. That's not the violation that's alleged, right? Instead, it's being in an enclosed space, which did not exist. And the photography, I don't know what the photographs that you're reviewing, because we haven't seen them.
Well, we'll show them to you in a second.
Okay, but if you have any other questions, I'll be happy to answer them.
Let's show them the pictures that we've just seen.
Chairman Duffy, I see no voters in those photos.
Photos say, the photos are the photos. What they show, they show.
Beg your pardon?
What they show, and we're going to show them to Mr. Brown.
Mr. Brown, please.
If you want to step back and show them to Ms. Marks, you can.
Let me just check with my client to make sure I got my facts right on this.
Okay, sure.
I do want to mention one thing, Your Honor. Judge, the page 5 of 7 of the photographs, and we need to look at all of them. This is a distorted image because what it is a zoom, is a cropped. If you take I've seen the larger size one of this, and if you look at the normal size of this, you'll see about 20 tiles in the floor between Ms. Martin and the machines, but it's compressed because they've cropped it, as you can do. And so they've taken a somewhat accurate photograph and given you a crop that makes it look like she's much closer than she is. So that's troublesome. But more important is we're not here to defend a charge of violating an election law of standing too close to an election machine, because there's no such law. And there's no jurisdiction to enforce a non-existing law. And
I don't see a charge of standing too close.
right.
The charge is being within the enclosed space. And you say there is no enclosed space. I understand the argument.
I believe so, and I think that's confirmed by the county's observations as well. Thanks.
Well, let me understand, your argument is that because there was no barrier, everything was the voting room, and that even though people were in there and were able to vote on machines, that there's nowhere in that space that was the enclosed space. That's your legal argument.
Yeah, the law defines enclosed space.
No, I just,
Yeah,
look,
that is the argument.
Your argument is, in
Yeah,
this case, there was no enclosed space, and because there wasn't, anybody could go and watch and people vote and stand around machines, because that's allowed, because it's only the voting area.
The law says you may not go into an enclosed space,
Look,
and that there wasn't one. There wasn't an enclosed
you're
space.
saying, and that means that because there was no enclosed space, there is no prohibition from a person going into the voting area and looking at anything they wanted to look at.
Yes, Your Honor. In fact, the law says that in the voting room, the public must have access. It's not that they got away with doing something that is wrong or should be wrong. It's that they did what the law expressly allows and requires the county to provide.
Look, I understand your legal argument. I'm just saying, does that mean that if somebody wanted to stand next to a voter and watch them vote because they're only in the polling area, that they could do that?
That's a crime, okay? That actually is a crime to do that. Watching somebody vote is a felony. So no, they could not do that.
Well, we all did in law school, let's change the facts.
Sure.
They're not watching the person cast the ballot, but they're inside, they're a foot away from the voter, and their back is turned to the voter, so they're not watching the voter, but they were watching the environment in which the voter. That's okay under your definition, right? Because they're not within the enclosed space, because there is no enclosed space.
I would ask the same question, is what law would that
No,
violate?
look,
I mean,
this works. He asked you a question, you answer it, and then you
those aren't the
answer it.
facts here, because there's no picture of a voter.
But I'm just trying to get your definition down.
I don't know of what law that would be violating, okay?
If we accept your definitions and your argument, we have to also accept that if someone is standing right next to a voter but not watching them vote, they haven't done anything wrong. That's where your argument puts us.
No, it's not.
Okay.
If the county is doing what it's supposed to do by having an enclosed space, then that should not happen.
But in the absence of an enclosed space, it's perfectly fine, right?
The law, we need to follow the law, not drag it. Okay, the law says that the county's supposed to have, it's not that hard. The law, the legislature has decided this for us. And the legislature has decided that several things. One, there needs to be enclosed space, which is different than the voting room. Two, that you need to be able to view voters